conduct search in the respondent's premises and dwelling houses, and carry away exhibits, any electronic gadgets and devices, or any other evidential material, and exploit the relevant electronic gadgets, including the respondent's mobile phones, make Nokia. Nokia C32 of email number 355 321 870 33 9000 and 355 321 870 33 9018. Techno CM5 of email number 3584 91 28 196 8148 and 35 491 28 444 456 15. Lastly, HP Elite book, serial number 4A84 82 1C C3213. Your Honor, briefly the facts in the matter are that the IO is undertaking investigations into fraudulent social media, and that through the connection they are able to assist candidates to alter their results to higher grades. Your Honor, investigations have established that the two respondents before you are admins in several social media platforms which are under investigations, and if released they are likely to jeopardize the ongoing investigations. Your Honor, further, the investigation so far revealed that the two respondents are individuals operating the said groups and are soliciting money from unsuspecting members of the public, whom they have recruited into the groups, and that they have provided specific phone numbers through which an amount of money should be sent before the grades are changed. The amount of money to be paid is determined by how high one's desired grade is. The respondents who are said to be admins of the social media groups share photos of Kenya National Examination Council offices and purported Kenya. Of the Kenya National Examination Council offices and purported Kenya National Examination Council portal on the grading system to convince members of the public that they indeed work at NEC headquarters, KNEC headquarters. In an effort to bring to an end the deception perpetuated by these social media groups, DCI officers traveled to Nyanza region in search of the suspects, and they were able to apprehend the second respondent. Arrested at Migingo within Kisumu County, where he had gone into hiding, while the first respondent was arrested within Tongai. At the time of their arrest, the police managed to seize mobile phones from them, which were found having been logged into Telegram and WhatsApp groups that are under investigation. Your Honor, the same social media platforms are believed to have been opened and operated by the respondents since they are the admins. Your Honor, the handsets seized are believed to operate the social media platforms perpetrating the crime since the year 2024 KCSE exams, and hence believed to contain large volumes of data. Your Honor, the data to be retrieved from the handsets requires time to extract. Thus, we pray for 7 days, which we believe is sufficient and reasonable. Your Honor, this evidence is critical in preferring charges, thus must be extracted before presenting the respondents before court for plea taking. Your Honor, from the IOS application and supporting affidavit, the three main grounds that come out clearly are number one, the nature and gravity of the alleged offenses. Which warrants continued custody at this stage. Your Honor, the alleged offenses involve allegations of deliberate misrepresentation and financial inducement, which require careful examination of documents and electronic evidence that is still being pursued. and processed. Your Honor, the prosecution assures the court that the request for 7 days is reasonable, proportionate, and time-bound. The DCI undertakes to conclude investigation within this period and return the suspects to court immediately upon completion whether for charging or for any other appropriate order. Your Honor, finally, the application balances the rights of the suspects with the public interest in effective administration of justice, the requested 7 days custodial period is not punitive, but purely investigatory, aimed at enabling the prosecution to discharge its constitutional and statutory mandate. Your Honor, in the circumstances, the prosecution humbly prays that the court be pleased to grant a custodial order of 7 days to allow the finalization of investigations. That is all, Your Honor.
First and the second respondents, you are developmentally propose the notice of motion for you. The copy I have is undated. See the affidavit is equal undated, non-commissioned. I don't know whether your copies are commissioned or dated. Initially they were seeking 14 days, now it has come to 7 days. The said application doesn't meet the threshold as stated pursuant to Article 49(1)H of the 2010 Constitution. which requires, Your Honor, that pending any charge or trial, the accused is entitled to be released on cash bail unless there are compelling reasons. Your Honor, I've looked at paragraph 1 up to paragraph 29 of the supporting affidavit sworn by one John Kariuki. There is no single paragraph, Your Honor, that states or demonstrates compelling reasons. There's none whatsoever. Perhaps I could have indicated that there is a freight risk and go ahead to demonstrate how freight risk they are. There's none. There's no demonstration whatsoever. Perhaps that they would interfere with witnesses. None whatsoever. Or perhaps the complexity of the case. The preferable offenses or charges have been stated in the affidavit and the notes on the face of the notes of motion. That's pursuant to paragraph 2, subparagraph 1, and paragraph A and B of the notes of motion under the prayers being sought. One of the two offenses are in false publication and obtaining money by false pretenses. These are felonies under the penal code and under the Computer Misuse and Cyber Crimes Act. These are available offenses. They are not grave offenses as alluded by the prosecution, such as perhaps capital offenses, for example, murder or robbery with violence, and perhaps maybe treason. These are bailable offenses. Allow me to state that the two respondents are not afraid as alluded by the prosecution. Respondent number 1, Your Honor, that is David. David Opio. He resides in Rongai. And indeed, the good IO does affirm in his supporting affidavit that he was arrested in Rongai. And upon his arrest, he was taken to his house. Where the two mobile phones, the numbers were earlier mentioned, there's no need for me to repeat the same. Technical phone CM5 was picked from his house. His laptop HP book was also picked from his house. And it is a lie now for the prosecution to state that they are afraid of this, and yet they know his place of abode. That is a total lie. The second, the first accused, the respondent, is a student. Is pursuing a diploma in primary education at Tibian TTC in Rongai.
Diploma
in primary education.
at
TBIAN, that is TIBIAN, TTC, Siburongai, is a first year student. But Karamol is really scheduled to attend make an appointment with a doctor, a dentist, on Wednesday. You know, the second respondent, that is Albert Kelly. You know, it's not true, as alleged also by the prosecution, that he has no fixed place of abode and that he was arrested while on the run. That's completely not true. You know, the respondent, the second respondent, hails from Midingo village, near Midingo Girls High School. In Karibu sub-county, that is within Kisumu County. That's where he was arrested from. And that is also equally confirmed by the good IO in his supporting affidavit. That is in paragraph 12 of the affidavit. Why would he then go ahead to lie that the respondent was on the run? That's not true. He's a student at Kisumu Polytechnic, pursuing a certificate in building technology. You know, purely, their places of abode are known. These are Kenyans. They were not perhaps arrested at the border of Busia or Malaba or Namanga trying to leave this jurisdiction, or perhaps at JKI, perhaps boarding a plane. You know, as such, they're not Africans. That allegation completely fails. The IO does mention that the other groups or other people that they intend to zero on that are colluding with the respondents in court. When the two respondents are not controlling their movements, nor are they harboring them. If I can pose a question, the longer these people stay at large, will the two respondents stay in custody for as long as those people are not in the hands of the DCI? Well, this is not one of the compelling reasons as invested in the Article 491H. These are purely speculations, innuendos, just aiming to punish the respondents, having them kept in custody for 7 days. 1, 2, 3, 4, 5, 6, 7, as opposed to the 24 hours as stated in the Constitution. It's very absurd. From the foregoing, Your Honor, I humbly pray that you dismiss this application Your Honor, the charges, the preferable charges are already known. The respondents are here. The gadgets are already in their possession. All the information they require is in those gadgets, and they are in their custody as we speak right now. Charges are found in paragraph 13. What else do they need from these two gentlemen, other than torturing them, having them kept in custody for 7 days? You know what that means? We therefore pray, Your Honor, that you grant them lenient custody as you exercise your discretion. Perhaps would be very glad as you exercise your discretion and your generosity if you could grant us perhaps 50,000 as they report to the DCI for any questioning or recording of a statement. You don't need to have these respondents or these young men detained just to record a mere statement, which takes only 1 hour. In the circumstances, Your Honor, you decline to perhaps grant them cash bail, and you have perhaps be detained, be humbly beseeching, Your Honor, if we can come back before you, give them maybe 3 days from the 7th they are requesting, or 2 perhaps, this not later than Thursday, that is the 22nd of Jan 2026. That's the humble prayer. Thank
you. Dated 19th of January 2026, filed hearing and the affidavit sworn by number 241289, Inspector John Kariuki, on the same date, that is 19th of January 2026. From the contents of prayer number 2 of the application and ground number 11 thereon and paragraph 13 of the supporting affidavit, there is indication that the items which form the basis for the search warrant sought under prayer number 2 are already in police custody, having already been recovered at the time of arrest. Having been so seized at the point of arrest, the investigating officer may proceed with forensic analysis and examination thereof with a view to identifying data relevant to these investigations and the extraction of the same. With regard to prayer number 1 for pre-charge detention for a period of 14 days sought in the application, the submission by the defense counsel for the respondents that the respondents were apprehended at their places of abode is not disputed. I do not see any compelling reason established in line with the provisions of section 36A of the Criminal Procedure Code to warrant continued detention of the respondents, considering that the application does not disclose when the 2 respondents were arrested, and the allegation by the defense that they have been in police custody beyond the 24 hours period provided for by the Constitution is not disputed by the prosecution. Based on the material before this court, at this stage, granting the respondents bail will not in any way jeopardize the ongoing investigations, Each of the two respondents is therefore granted cash bail of Kenya shillings 70,000 with one contact person each, on condition that they avail themselves to and cooperate with the investigators as and when required within normal official working hours. The matter we mentioned on the 2nd of February this year, and until the respondents post the bail, they will be held at Muthaiga Police Station.
Pending the